We're opening with assault charges right out the gate. And not just any assault, family assault. Court drama always cuts deeper when it's family against family. Already, you can feel the tension building.
Good morning, Miss Lathan. Thank you, Mom, for coming. Appreciate it. Miss Lathan, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Okay.
Judge, the complainant reported being assaulted by the defendant, who is the complainant's daughter-in-law, at the defendant's residence in Harris County, Texas. The complainant stated she was at the residence with the defendant for the complainant's son's birthday. The complainant advised she engaged in a verbal altercation with the defendant about the child not saying goodbye. The defendant got into the victim's face and the defendant lunged at the complainant.
Whoa, that detail changes everything. A kick after breast cancer surgery? The prosecution just added a layer of cruelty to the story. But notice, this also raises a huge credibility question later. Could the defendant even kick that high? That's the kind of fact defense lawyers love to dismantle.
As if the defendant was going to strike her. The complainant stated her son and husband attempted to separate the defendant and the complainant, but the defendant was able to kick the complainant's right breast, causing a high level of pain due to recent breast cancer surgery. The complainant stated the defendant yelled, quote, "I will fuck you up," as she was pulled away. The defendant stated they had a get-together for the defendant's husband. The complainant became upset during that conversation, and the complainant was slamming doors, yelling and getting in the complainant's face, but did not kick the complainant as she was 9 months pregnant. The defendant was identified with a Texas driver's license.
I make a statement, Judge. And so this case was it 6 months later that it was filed? They never spoke to any of the witness. Janitha was present at that time. Terrell, who's a bailiff upstairs, was present at that time, which is Jillian's husband. He didn't want to go through the whole IED deal and give a statement just yet.
6 months later. In legal time, that's an eternity. Delayed reporting often makes cases wobble. Witness memories fade, stories shift, and defense attorneys are ready to pounce on that gap. The jury hears 6 months and already starts wondering, why now?
But I did provide a witness statement from Janitha where she was there. She was 9 months pregnant at the time, Judge. She had her baby a week later. Her mother-in-law did have breast surgery, cancer surgery before on her breast, but she couldn't lift her leg up 3 inches, much less high enough to kick her in the breast. Police officer had none of the information with regards to Janitha being present. Janitha was there. There was the mother and the Terrell and the father holding the two back, I guess, from each other like this. It was split up and then that was it. 6 months later.
Here's where the judge drops some courtroom wisdom. Probable cause isn't guilt. It's just enough smoke to go looking for fire. Think of it like a checkpoint, not the finish line. The real showdown comes later at trial, when the standard rockets up to beyond a reasonable doubt.
Charges were filed against Miss Lathan, and that's it. Officers never spoke with anyone, didn't get the other side of the statement. Janitha did provide a witness statement. The court can ask Janitha. We're open to the court asking the questions to Ms. Kimbrough. She didn't witness anything after it was split up. They went home, I guess, Janitha, and then that was it. There was no physical contact, anything of that nature. Nothing.
Give a response, Mike.
Judge, I haven't read the offense report thus far. I know that this is what the victim has reported. I don't know who the investigator spoke to, but I know this was a delayed report. That's why the 2B warrant was filed.
There was no documented injuries, Judge, no photographs, no nothing. They just on their own volition.
Remember, this is just mere probable cause, right? So, and the fact that, she's pregnant is unable to, I don't know that, right? So, all this is a probable cause. It doesn't mean that you're guilty, right? It's a mere probable cause. There's still a lot before someone can be found guilty beyond a reasonable doubt. I mean, that's a lot higher standard than what we're just doing today. I am going to find that there's probable cause to go forward. What's the dynamic now? I guess it's 6 months down the road.
I mean, do
they want to have contact?
Do you still have contact with your mother-in-law?
So on Marilyn, Is there still contact between you guys?
On and off, not too much.
Okay, so the only thing I'm gonna ask is just don't have any threatening or harassing contact with this person. That's all I'm gonna ask you to do at this point, okay? I'm not gonna put any other conditions in your bond. Just be careful. Don't pick up any new cases. You know, you got a great lawyer. I will waive your appearance. You don't have to waste your time coming to court. Mr. Kamek will tell you when you have to come back to court, and just, that's all there is to it. Just, you know, just be nice. Don't pick up any new cases, you know? You guys have any questions?
That's it. Yeah.
So for now, what I'm gonna do is I'm gonna have just Michael create the bond conditions, we'll have you sign it, and then you guys are free to go. Just do your thing, and just have fun.
Judge, did you set a bond amount?
Oh, Mr. Torres, you're charged with assault of a family member. You are facing a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 15, 2024, officers dispatched to a welfare check at a residence in Harris County, Texas. Officers made contact with the complainant, who was observed to have a fresh, large bump to the back of her head. The complainant was observed to be very scared.
This is chilling. When a victim whispers, "I don't want to die," that's not drama, that's raw survival. And when the accused is allegedly making death threats mid-argument, that's not just assault territory, that's protective order, emergency measures, and serious bond restrictions.
Speak to law enforcement at the time of their arrival while the defendant was in the area. The complainant insisted that she wanted to leave the house and get out. The officers made contact with the defendant, who stated that him and the complainant had been dating for about 1 month and had recently had a couple verbal arguments. The defendant stated that he was outside and heard screams coming from inside, and when he came inside, he found the complainant on the floor in the living room and that she had fell from the stepping stool that was in the living room. The defendant stated that the argument never got physical between them, and the officer contacted the witness, who called in the welfare check and stated that he received a message from the complainant of a picture of a firearm. The witness stated that the complainant began sending him audio through WhatsApp, and on the audio you can hear the complainant say, "Jose, run. He is going over there with a firearm, run now." The second audio that was sent from the witness, you could hear the complainant telling him, "I was able to take the firearm away from him, but he had a knife, run." The witness stated he called the complainant and was able to hear a disturbance between the complainant and a male. The complainant tells the witness, "I don't want to die," and the witness then overhears a male yell, "If you call the police, it will get worse." And then that's when the witness heard them arguing, and he can tell the defendant's mouth was then covered and can no longer talk. And then the complainant stated the defendant was upset that her ex-boyfriend was trying to pick her up, so the defendant placed a firearm inside his waist and said he was going to look for her ex-boyfriend, and he left the house. The complainant stated the defendant returned a short period later and continued to argue with her about leaving the house. And when the complainant was exiting the master bedroom and going towards the living room to leave, the defendant pushed her back, causing the complainant to fall to the ground and hitting her head with the floor. The complainant stated she lost consciousness after she fell, but when she woke back up, she was already laying on the bed when the defendant was there pleading that he was sorry and he didn't mean to hurt her. The complainant stated she did feel pain. And that's it, Your Honor.
So it is the pushing and falling on the floor and getting
Yes,
hurt that way. Okay. Mr. Torres, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? You don't understand?
No, not one time.
He said no, he's not going to have contact.
Okay. I'm also ordering you not to be in possession of any weapons. No guns. Do you understand?
No.
Yes, sir.
If I find that you have a weapon, if I find that you try to have contact with this person, I'm going to put you in jail and you will not get any more PR bonds. Tell me, are you a United States citizen?
Yes, sir.
You are?
I'm sure.
I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Yolis Hernandez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file an additional charge against you, violation of a protective order, and then it's really bad. Do you understand?
Yes, sir.
If you ever have any questions, Mark can help you and guide you through this. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Mr. Metz, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. So don't pick up any new cases, no contact and no weapons. That's it. Do you have any questions? Okay. As far as the bond is concerned, we need to take care of that.
Yes.
Do you have any prior criminal history that you guys see? Alex?
I can run his NCIC.
In Texas, no, Your Honor. I don't know. Outside, I doubt anything outside.
7 open charges. This man is basically running his own criminal franchise. Judges don't like stacking risk on risk, and multiple pending cases scream flight risk and danger to the community. Defense attorneys can argue all day, but those numbers speak louder than excuses.
Your Honor, I don't see any other criminal history.
Okay. Mr. Torres, I'll set your bond at $500 and I will give you a PR bond today. Okay? But I will not give you another PR bond. If you pick up a new case or violate these conditions, I'm going to take that PR bond in a moment's notice. You understand? Okay, my friend. So take a seat. We'll have you sign all the documents, but don't leave until we let you go. Okay? All right. Okay. You want to do the other gentleman?
Yeah, let's do that.
Is this,
Mr. McDonald, Jonathan McDonald.
all right. So, Mr. McDonald, your lawyer wants me to set you a bond. I don't know anything about you. I've never met you before. I know you're going to tell me it's little bunnies jumping in the woods, but my main concern are 2 things. Are you a danger to the community? Number 1, if you're not, and my other one is, are you going to go back to the jurisdiction you're wanted from? My other main concern is what you're wanted for, because I don't know. So, Amy, tell us about Mr. McDonald.
Yes, Judge Crutcher. So he's wanted from Faulkner County, Arkansas for a theft by receiving $1,000 to $5,000. It's a felony. You looked at his criminal history and would be opposed to a bond at this time. That concerns a lot of danger to the community. In particular, he had in 2024 an arrest that resulted in 7 open charges.
So he had 7 open charges did you say last year?
This year, 2024.
Oh,
Yeah. Felony possession of a firearm by certain persons, driving with license suspended, failure to pay license fee, theft by receiving, which is separate from this one. And then a fake license plate, possession of controlled substance, and possession of drug paraphernalia. He's also had in 2021 forgery dismissed, felony property dismissed, felony domestic battery 18. He's had a federal firearm charge from 98, federal assault on a postal employee from 99 that ended in probation. And he's had 2 guilty convictions for theft of property and burglary of 88. So at the time, we should be asking for no bond for those reasons.
is he on probation or parole right now? Do you know?
Not that I know of. Dave's gonna come up in a second to tell you for sure, but I don't see that he's on it now.
What's your position?
Judge, we're asking for a bond because it looks like the Faulkner County, Arkansas case, this theft by receiving, it's not violent. Additionally, it was a warrant, so there's no failure to appear or any issues like that.
His 8th charge this year, right?
I wasn't aware of that.
Can I speak?
Yes.
Sure.
Okay. She asked me about being arrested.
Let's not talk about the case.
Oh, okay.
We're talking about my case. My only
Okay.
concern is, you've got 8 cases this year.
8 cases this week.
May I to the judge? Okay, Judge. I flew into Arkansas. My mom was dying.
Whoa, let's not talk about
Well,
that.
I have to give him some background so you can see what happened. I borrowed my ex's vehicle.
No, let's not just talk about that. Let's just not talk about that.
Okay, well, let me get to it. That's been just, I don't know why that ain't showing up. That's been dismissed. The only thing I've been charged with, the only thing I've agreed to is paraphernalia and her vehicle, not mine, her vehicle. but she's saying, everything.
Is it dismissed? Or out of the 7 charges, what happened?
I'm saying that they're
It was
arrested. Dave
dismissed.
said that they're open charges.
It was dismissed.
Still open.
That's what Dave said. But I am saying that he was arrested for them.
They're all still open.
The prosecutor dismissed all that gun stuff and all that. My lawyer just contacted me last week. The date where everything was supposed to have been done, they changed it to January 25th. I'm pleading out to the insurance and stuff on the vehicle.
Notice the shift. The judge isn't just ruling, he's preaching. When a judge turns philosopher in the middle of a hearing, it's their way of saying, the law can only protect you so much. The rest is on you. It's half warning, half fatherly advice, but make no mistake, it still carries legal weight.
My vehicle, I'm pleading out to because I was driving it and paraphernalia.
Okay, so in
That's
January
it.
you'll be pleading.
To prepare for that. Yeah,
So
misdemeanor.
all 7 cases are still.
Everything gone. Only thing is,
My concern is that when you have all those open cases, it makes you more of a flight risk.
I've never fled from anything. In fact,
But you're here.
listen, I didn't flee. I never had
I think it was, they filed a new case.
They
He's saying
filed, I
that
was
it
home.
wasn't, he did not flee, it was a warrant.
Is it 2B?
Yes, that's what my client stated.
But what I will tell you, Your Honor, the conviction she made in 1999, granted, yes, I did go into federal custody. The judge gave me a self-surrender. They sent me a letter saying, be here at this time and this date. I was there. I got there June 14th, 2 o'clock,
You don't mess
1999.
with the feds.
I didn't come out till 2004. But what I'm trying to tell you is, I got sent a letter to come to prison knowing I wouldn't get out for 5 years. I was there. I've never ran from anything. I'm not dangerous. I've never not answered anything. Nothing. You will never find that. I've never escaped anything. In fact, if I just be honest with you, Your Honor, I don't even really know if you give me a bond, make it. So I'm like, I told her, you know what? I just do the 14 days
So
or
you don't
whatever.
want a bond?